Welcome to this Conduct an Investigation into Workplace Safety, Health and Environmental Incidents. Within this course program, we are going to be looking at the overview of incident investigations, how to conduct the investigation, the legal documents required for the reporting and recording of incidents and accidents, as well as learning from different incidents and accidents that could occur. The investigation and analysis of work-related incidents and accidents forms an essential part of the management of health and safety. Learning lessons from experience is critical to preventing future accidents and incidents. Carrying out an accident investigation provides a deeper understanding of the risks associated with the work activities. Learning what went wrong enables improvements to risk control measures and management arrangements for supervision and monitoring. Let us now take a look at the aim, legal reasons, and benefits of incident management. It is to be noted that the aim of incident management is to learn from the experience and to gain an understanding of how and why things went wrong, what really happens, and how work is really done, as well as any deficiencies in risk control management, enabling improvement going forward. There are also specific legal reasons. For monitoring and reviewing health and safety arrangements, the accident investigation plays an important part in this process. For disclosing information for use in civil action, as well as insurance companies will also require the findings of investigations when dealing with compensation claims. The benefits, however, far outweigh the cost. The broader business benefits will include the prevention of further similar adverse events, the prevention of business losses due to disruption, stoppage, loss orders, or the cost of legal actions, an improvement in employee morale and attitude toward health and safety as a consequence of positive action, as well as the development of managerial skills such as problem solving and action planning. When determining how and why incidents and accidents happen, the end result should bring you to the root cause of the incident and give clear evidence of the area of concern. Knowing how things went wrong can assist a company in determining what should be implemented or changed to address the cause. This will lead to a more robust and effective management system. This is also in line with the requirements and duties of employers to their employees. Let us take a look at the reminder of Section 8 of the OHSS Act. When looking at Section 8 of the OHSS Act, the term reasonably practicable means practicable having regard to four things: the severity and scope of the hazard or risk concerned, the state of knowledge reasonably available concerning that hazard or risk, or any means of removing or mitigating that hazard or risk, the availability and suitability of means to remove or mitigate that hazard or risk, and lastly, the cost of removing or mitigating that hazard or risk in relation to the benefits deriving therefrom. Section 8 of the OHSS Act. Duty of the employer. Every employer shall provide and maintain, as far as is reasonably practicable, a working environment that is safe and without risk to the health of his employees. Without derogating from the generality of the employer's duties under subsection 1, the matters to which those duties refer include in particular a. The provision and maintenance of systems of work, plant and machinery that, as far as is reasonably practicable, are safe and without risk to health, taking such steps as may be reasonably practicable to eliminate or mitigate any hazard or potential hazard to the safety or health of employees before resorting to personal protective equipment. C. Making arrangements for ensuring, as far as is reasonably practicable, the safety and absence of risks to health in connection with the production, processing, use, handling, storage, or transport of articles or substances. D. establishing as far as is reasonably practicable what hazards to the health or safety of persons are attached to any work which is performed, any article or substance which is produced, processed, used, handled, stored, or transported, and any plant or machinery which is used in his business. And he shall, as far as is reasonably practicable, further establish what precautionary measures should be taken with respect to such work, article, substance, plant, or machinery in order to protect the health and safety of persons, and he shall provide the necessary means to apply such precautionary measures. E. Providing such information, instructions, training, and supervision as may be necessary to ensure, as far as is reasonably practicable, the health and safety at work of his employees. F. As far as is reasonably practicable, not permitting any employee to do any work, or to produce, process, use, handle, store, or transport any article or substance, or to operate any plant or machinery, unless the precautionary measures contemplated in paragraphs B and D, or any other precautionary measures which may be prescribed, have been taken. G. Taking all necessary measures to ensure that the requirements of this Act are complied with by every person in his employment or on premises under his control, where plant or machinery is used, enforcing such measures as may be necessary in the interest of health and safety, ensuring that work is performed and that plant or machinery is used under the general supervision of a person trained to understand the hazards associated with it and who have the authority to ensure that precautionary measures taken by the employer are implemented. And J. Causing all employees to be informed regarding the scope of their authority as contemplated in section 37(1)(b). So what does this piece of legislation mean? It means that every employer must know and understand the type of work they perform, the machines, equipment, tools, materials, and method of work performed, and then identify how this can be dangerous to employees. The employer should know what can harm an employee, how it can harm an employee, and why it harms the employee or any other person who may be affected by any risk or hazard associated with his tasks. When they understand this, then they need to create a set of procedures that are developed into what we will call a system of work, or a way of doing something, the methodology of keeping everyone safe. This system then tells employees what the job is, or scope of work, and then what the dangers are. After this, the system of works is established to help employees understand how they can then do the job safely. These are the precautionary measures that must be taken. There are many forms of documentation that can be used within the safety management system, all of which can assist the employer to carry out their duty to safeguard their employees or any other persons who may be affected by their work. Here are some examples of documentation that may be required in order to ensure a safe management system. These could be risk assessments, method statements, safe working procedures, safe operating procedures, inductions, appointments, and training. While going through incident and accident management basics, as well as the incident investigation procedure, these definitions will apply to accident, means an accident arising out of and in the course of an employee's employment and resulting in a personal injury, illness, or the death of the employee. The definition for incident means an incident as contemplated in section 24.1, including other less serious or minor incidents, and therefore used as a generic term as well. With a reference to section 24 in this definition, we are referring to the Occupational Health and Safety Act, section 24. A near miss, means an incident that had the potential to cause injury, ill health, or property damage, but did not. An unsafe act means doing or omitting to do any act which it would be an offense in terms of the Occupational Health and Safety Act. An unsafe condition means a set of conditions or circumstances that have the potential to cause injury or ill health. In summary, the duties and responsibilities of employers to employees or any others with regards to occupational health and safety, as well as incident management, are the following: to provide and maintain a safe working environment, to provide and maintain safe plant and systems of work, including, for example, identifying, assessing, and controlling hazards, providing information, instruction, training, and supervision of employees to ensure and enforce health and safety, ensure the safe use, storage, and handling of substances or articles, providing adequate facilities for staff, as well as consulting with employees and health and safety representatives about occupational health and safety.